Dear learners, we shall be continuing with our lectures on the various kinds of business organizations which are available under the business law. In this part 7 lecture, we shall be discussing two important business organizations, that is corporation or body corporate, and then sole proprietorship. So in some of our previous lectures, we have had an overview of the various kinds of business organizations, as well as we have discussed in detail one kind of a business organization, that is a company. Now we will be taking up two other kinds of business organizations, namely corporation and sole proprietorship. Corporation is also known as a body corporate. Now, examining the expression corporation or body corporate, both of which are used interchangeably in common parlance, this expression corporation or body corporate is very closely aligned to that of a company, which we have discussed in the previous lectures. So it is defined under section 2 subclause 11 of the Companies Act 2013. According to this provision, a body corporate or corporation includes a company incorporated outside India, but does not include, or rather it excludes, number 1, a cooperative society registered under any law to cooperative societies, and number 2, any other body corporate not being a company as defined in this act, which the central government may by notification specify in this behalf. So as you would have realized, this is a rather technically worded definition which does not reveal much about the concept and features of a corporation. So the expression body corporate or corporation as defined under section 2 subclause 11 of the Companies Act, it includes a company which is incorporated outside India and a company that is, so the expression body corporate or corporation as defined under section 2 subclause 11 of the Companies Act, it includes a company which is incorporated outside India, but it does not include a cooperative society registered under any law relating to cooperative societies. The differentiation between a company and a body corporate is defined very lucidly by a judgment of the Supreme Court of India in the case of Ashok Marketing Limited versus Punjab National Bank, a judgment of 1990. It has explained the term body corporate or corporation in the context of modern corporations. Thus, the expression body corporate is wider than the term company. So, every company that is registered under the Companies Act is a kind of a body corporate. However, every body corporate may not be a company. So, the expression body corporate would include all corporations that are created under special acts of parliament or legislature. So, for example, universities formed under legislations are body corporates. However, they are not companies. So, every corporation is not a company, but every company is a kind of a corporation. So, it is important to bear in mind that an incorporated company is a body corporate, but it is not true the other way around. Now, this is not the only way of creating a body corporate. So we can say that a body corporate is a genus of which company is a species. Moving on to sole proprietorship. A sole proprietorship is one of the simplest and most popular forms of business organization in India. It is a business that is carried on by only a single person. The decision making and management of the business is in the hands of a single person. It is commonly chosen by small and local businesses such as grocery stores, parlors, boutiques, retail stores, etc., which can be established on sole proprietorship business model. Even small traders and manufacturers can establish a sole proprietorship business. Now, the features of sole proprietorship are that it does not have a separate legal personality, and the business has got unlimited liability which has to be borne by the owner of the business. This is in stark contrast to a company which has a separate legal personality and limited liability. The sole proprietorship, because there is a soft legal regulation, so there is no one specific legislation that regulates the legal framework of sole proprietorship, and because of less complexity of the nature of this business, it is generally regarded as very easy to form and operate, as meant for small businesses. The documents and procedure that are required to establish a business of proprietorship is also relatively minimal and include only basic documents. Now, some of the key features of proprietorship are, as we've discussed, one is ease of formation, that is starting the business, and dissolution, that is ending of the business. The other is that it grants exclusive control or management or ownership to a single person. This is somewhat different from that of a company, which, as we discussed in the previous lectures, there is a separate body like the board of directors which manages the business, and there is a separate body known as the shareholders who own the business. Now, this separate legal entity is not present in case of proprietorship, meaning thereby the business is associated with the individual owner, and the proprietorship does not have any legal personality of its own, again unlike that of a company. So in that sense, sometimes it could be difficult to have continuity in the business when there is any death or incapacity of the owner of the proprietorship, and he is also the individual risk bearer of the business. As a risk bearer of the business, while he himself earns all the profits, he is also subjected to the various losses that are incurred by the business. Now, the proprietor of the sole proprietorship business bears unlimited liability, and he is personally responsible for all the debts of the business. If for any reason the funds are insufficient, then the personal assets may be used to settle business liabilities. So, the business creditors of the sole proprietorship business, they do become the personal creditors also of the sole proprietor. So, this aspect of owner shielding is not present in sole proprietorship. So, since sole proprietorship is not considered a separate legal entity, no specific criteria are provided for starting a proprietorship business. However, a person should be a tax-paying citizen of India, and he should otherwise be legally competent to start a business. Now we are going to look at what is the registration procedure or a process for starting a proprietorship business. Especially this is going to be useful for upcoming or budding entrepreneurs. So the documents and procedure which are required to establish this proprietorship business, as I've said, is bare minimum and includes only basic documents and registrations. So to begin with, the proprietor should have a PAN card, and he should decide upon the name of the business. The next is that he has to open a separate bank account in the name of the business, and all business transactions shall be conducted through this bank account. Apart from this, certain basic registrations are required. For example, registration of shop. Now, different states have different laws relating to this. So, for example, uh, under the Shops and Establishments Act of the respective state, if required, the shop or the place of the business, it has to be registered, and the proprietor needs to obtain the registration certificate. So, for example, under Uttar Pradesh, we have the Uttar Pradesh Dukan and Vanijya Adhistham Adhiniyam of 1962. The proprietor should also register for GST if the turnover of the business exceeds 20 lakh rupees. Now, registration under the Micro, Small and Medium Enterprises Development Act can also be beneficial, but this is optional. So, for that, registration has to be done on the Udyam portal as provided on the Government of India website. So, there are certain benefits of registering the proprietorship as micro, small, or medium enterprise. However, this is not mandatory. Now, proprietorship has got some advantages and disadvantages. Beginning with its advantages, it is easy to start as there is no rigorous procedure that is required for starting the business, so it could be started from any place or home. And once you get down to doing the registration process, I think it could be completed within a week or 10 days. So in the same way, the process of ending the business is also very uncomplicated and simple. If you decide to close or dissolve your business, you can cease to continue with your business operations without undergoing extensive formalities or approval from regulatory authorities. The next is quick decision making and flexibility. Now, because it is owned and managed by a single person, the decision making becomes easy because most of the decisions are being taken by the proprietor himself or herself. So there is not much of consultancy or consultation that is required. It is economical because the business has fewer registrations and compliances, and generally this is for small businesses. So the running cost and operation cost of a proprietorship business, it is less and economical. Then the number of compliances that are required with the legal or regulatory authorities are less. Again, this is a kind of an advantage. The next is the proprietor exercises a high degree of control over the business, which is unlike that of a company where the shareholders do not have direct control over the business, but it is done by the board of directors. Now, as the sole owner, the owner can retain the profits that the business generates. He can use them in whatsoever way they like. So they can use them for their personal expenses, and they can also reinvest in the business. So there is no need to share the earnings with other business co-owners or partnership. Therefore, profit retention is high in case of a proprietorship. Now, sole proprietorship also offers a higher degree of privacy since there is no legal requirement to disclose financial information publicly. So, business activities and financial records can remain confidential, giving you a certain level of discretion. Now, there are certain disadvantages also of proprietorship. One is the aspect of unlimited liability. Now, what is limited liability? What is unlimited liability? We have already discussed it in great detail in the context of a company. So, because of unlimited liability, there is a greater degree of responsibility and onus on the proprietor to maintain the business in good financial health, and the debt ratio of the business should not exceed beyond a certain limit, because then the creditors, they have a claim on the personal assets of the proprietors. The second is that on the death or incapacity of a proprietor, the business can come to an end. because it does not have perpetual succession as compared to a company. And in a proprietorship model, it will be very difficult to raise funds because you cannot associate other owners with your business as co-owners, like in case of partnership where there could be multiple partners who could bring in funds. So you have no option to offer co-ownership of the business. So like in a company, there could be multiple shareholders. In case of a partnership, there could be multiple partners. Everything has to be borne by a single individual. Therefore, it does pose a risk, a difficulty of raising the funds. So that is why we say that proprietorship is usually recommended for small businesses in which fundraising, extensive fundraising from the public is not required. Now we will briefly compare a company with a proprietorship. So beginning with the formation. So a company is registered under the Companies Act, whereas for proprietorship, no formal registration under any act is required except some basic registrations. So legal framework is the Companies Act 2013, whereas for proprietorship there is no specific law. Now the governance of the company has to be done according to the documents known as the Memorandum of Association and Articles of Association. Whereas in case of a proprietorship, the proprietor or the owner is all powerful. So he can decide when and what business decisions he has to take. Now a company can engage in business or charitable activities. So some companies with charitable objects, they are provided under Section 8 of the Companies Act, which we will discuss later in the various kinds of companies, whereas for a proprietorship, they can only do business and not any charitable activities through it. So the purpose of a company can be for profit or non-profit, whereas for proprietorship, it can only be for profit. So the profit sharing in a company depends upon the shareholding pattern of the company. So the profits are distributed according to the shares that are held by the different shareholders. Whereas in proprietorship, all profits go to the single proprietor or the trader. Now in case of a company, the number of members can be 1 to any number of members. So 1 member we have for a 1-person company. And then there are other kinds of companies like private or public which have greater number of members. But in case of a proprietorship, such option is not available. Proprietorship can only have a single member. The liability of a company may be limited or unlimited. In practically, most of the companies register with limited liability as it is considered an advantage for the shareholders. But in case of a proprietorship, there is unlimited liability. For the legal personality of a company is separate from its members, and proprietorship, there is no separate legal personality, as we already discussed. The property of the company, therefore, is owned by the company itself as a legal person, whereas in case of a proprietorship business, it is owned by the proprietor. A company has got perpetual succession, meaning thereby its life is de-linked from its members, whereas not in case of proprietor. The concept of agency is not present in a company, so that the members are not agents of the company and they do not represent or bind some other members. Whereas a proprietor is an agent of the proprietorship business. So in a company, while most of the decisions they are taken by the board of directors, who are like agents of a company, but not the owners. Whereas in case of a proprietorship, the owner is an agent. So there is a difference, or there is a segregation between the management of a company and ownership of the company. Delegated management principle we have discussed in the previous lecture. Whereas in case of a proprietorship, there is a convergence between management and ownership. So generally, the owner is also responsible for management of the business. So the authority in a company is exercised mostly by the board of directors and not members, except certain fundamental decisions. Whereas in case of a proprietorship, all the decisions and all the authority is vested in the proprietor. So with this, we come to an end of this lecture. So a small part of the lecture was dedicated to a corporation or a body corporate as a business organization. Mostly there is a great degree of overlap between a corporation and a company. So corporation is considered to be an extension of the company. The only difference is that all corporations, they are not companies, but every company is a kind of a corporation. So corporation is a larger expression that include within its ambit the company. And then we have discussed in detail what is the sole proprietorship, what is the registration process, what are its advantages and disadvantages, and in what kinds of business sole proprietorship may be suitable and where it may not be suitable. So with this we come to the end of this lecture. We shall be continuing with some other kinds of business organizations in the subsequent lecture. Thank you.